New York State Racing Parimutuel Wagering and Breeding Law, Section 102, provides that the New York State Gaming Commission shall consist of 7 members, appointed by the governor, by and with the advice and consent of the Senate. 5 members having been confirmed by the New York State Senate affords the Commission an ability to establish a quorum and undertake action. This present meeting of the Commission is now called to order. Ms. Secretary, will you please call the roll?
John Crabby.
Here.
Peter Machete. John Bacumba.
Here.
Barry Sample.
Here.
Todd Snyder.
Here.
Mr. Machete had indicated that he was unavailable to attend today's meeting. The Secretary would please have the record reflect that a quorum of qualified members are present, thus enabling transaction of business. Given the absence of a designated chair, would the members like to select a member for the purpose of presiding over today's meeting?
I nominate John Crotty.
Second.
Mr. Chairman, Mr. Presiding Officer.
Yes. Thank you all once again. First item for business is consideration of minutes for the last meeting we had on December 21st, 2015. Those minutes have been provided to the members in advance. At this time, are there any edits, corrections, or amendments?
No. None.
Being none, the minutes were accepted. Now we will turn to a report from our Executive Director, Mr. Rob Williams.
Thank you. Just got a couple of items relative to the Jockey Injury Compensation Fund, World Park, Powerball, and Lasik.
Right.
At the December meeting, the Commission approved emergency and proposed rules to govern a default situation wherein the Jockey Injury Compensation Fund failed to timely submit an acceptable assessment and plan of operation governing premiums for the forthcoming year. The rulemaking was necessary as the governing statute contemplates that with the failure of the JICF to submit an adequate plan, the Commission shall adopt and promulgate such reasonable rules as are necessary or advisable to effectuate the law. If you recollect, the morning of our December meeting, the JICF filed a proposal for 2016. While that plan was unacceptable, I am pleased to report that following extensive discussion between the JICF, the Commission's legal and racing staff, an acceptable plan was approved. By law, the submission of the JICF of an acceptable superseding plan obviates the necessity for the emergency rulemaking plan to take effect. While the emergency rulemaking is no longer necessary and will be allowed to expire, it is necessary to continue with the proposed rulemaking to appropriately create a standing default provision to utilize should the JICF again to fail to submit a acceptable plan of operation and assessment. I think it's important to note that the premium of the accepted plan was consistent with that proposed by the Commission. The variance in costs reported in the news was solely due to differing mechanisms for the collection of individual costs. As many of you have read, Nassau Regional Off-Track Betting Corporation announced its intention to construct a temporary video lottery gaming facility at Belmont Park while they pursued legislation that would authorize their establishment of a permanent facility within the grandstand. Nassau seeks to use authority that is in the NYS State Settlement Bankruptcy Agreement. Any utilization of the Belmont property for video lottery gaming purposes involves an interplay between several statutes and various regulatory agencies. The Commission has received only one communication from Nassau regarding the proposal, which was a statement of intention. The present status of the proposal is unknown as there has been significant local opposition. Staff will continue to monitor the situation. As with a prior proposal by Nassau to site a video lottery gaming facility in Westbury, and with Suffolk Regional Off-Track Betting Corporation's proposal to site a facility in Medford, the Commission does not have permitting or site selection approval authority. Many news outlets have disseminated incorrect information relative to the Commission's role. I understand that the commissioners are prohibited by law in playing games that we conduct or regulate, but you might have noticed that the January 13th Powerball jackpot was landmark. It rose to $1.584 billion. While jackpot winners were from California, Florida, and Tennessee, the January 13th drawing produced 5 $1 million wins in New York, along with 2 $100,000 wins and 79 $50,000 wins. In total, over $18.8 million was won right here in New York. When looking at the entire period between jackpot wins, New York Lottery posted a total Powerball sales of $259 million and earned over $90 million for aid to education. State lottery retailers also earned over $15.5 million in commissions during that time.
Just to clarify, the $1 million is the 5 numbers with no Powerball?
Yeah, it's without the Powerball. Yeah. Full match without Powerball.
Well, that's tough.
Still $1 million
Yeah, understood.
on a $2 wager.
You were this close?
Finally, following consultation with several commissioners, the staff will be stepping up our examination of LASIK's practice in the United States. I've previously discussed information regarding various efforts at racetracks or jurisdictions in allowing LASIK-free racing. We will be looking to formalize our research approach and to try to determine the approaches taken by both racetracks and regulatory authorities, the ethical considerations of such actions, and the effectiveness of past efforts and the direction entities are considering for this upcoming year.
Great. Just on a purely personal point, can we, they probably listed on the Powerball website, right? How many people had 5 numbers?
Overall?
Yeah.
It is.
It's on the website. I'll check it out.
I'll email you
Yeah.
the number.
Thank you. Came close. Thank you very much for that, Rob. We will move now to rulemaking. New York State Racing, Parimutuel, and Wagering and Breeding Law authorizes the Commission to promulgate rules and regulations that it deems necessary to carry out its responsibilities. To that regard, the Commission will, from time to time, promulgate rules and rule amendments pursuant to the State Administrative Procedure Act. We have 4 items for consideration today. Rob, will you please outline the first item?
Certainly. As item 4A, Commission consideration of reproposal of rules regarding thoroughbred restricted time periods for various drugs. The rule proposal of concern was published in the New York State Register on September 30th, 2015, meaning that the public comment period expired on November 16th. The Commission's existing rules to permit the topical use of DMSO on the Commission's existing rules do permit the topical use of DMSO on race day. The Commission had proposed to replace this restriction with a new restricted time period, limiting topical use administration to 48 hours, while reducing the restricted time period for other administrations from 1 week to 48 hours. 2 public comments were received, one from the New York Thoroughbred Horsemen's Association and one from the Racing Medication and Testing Consortium. The RMTC suggested that Commission staff examine additional unpublished research concerning topical race day use of DMSO while restricting oral and intravenous DMSO administrations to 48 hours before racing. Staff found the additional research indicated that topical race day DMSO administration is appropriate veterinary care that would not result in threshold violations. NYFA requested that the Commission continue to permit the topical use of DMSO on race day, indicating that such approach would be consistent with many other states, such as California, Florida, Kentucky, and Pennsylvania. We did confirm that. Staff also consulted with State Equine Medical Director Scott Palmer and New York Drug Testing and Research Laboratory Director George Malin, each of whom opined that race day use of DMSO does not pose a threat to the integrity or the safety and health of racehorses, and they supported the topical race day use of DMSO. Given the comments received, staff recommends reproposal of these rules with that allowance included. A reproposal will trigger a new rulemaking publication and comment period.
Commissioners, any questions on the reproposal of the thoroughbred restricted time periods for various drug rules?
Yes, Mr. Chairman. I would just ask Dr. Palmer to give us some more information about DMSO for us uneducated commissioners.
DMSO is dimethyl oxide. It's a compound that is applied topically to the skin and is most notably, used to to go through the skin. It's able to transfer through the skin unlike other things. So it's an anti-inflammatory compound by itself, and it's frequently combined with other medications. And in rulemaking, I would make a distinction between straight DMSO and DMSO mixed with other medications. It would carry other medications with it as a vehicle into the body.
And we do that in that proposal, Rob?
Yeah, we will be consistent with allowing race day utilization of the MSO.
Thank you, Mr. Chairman.
Topical.
So, actually, I'm just not clear on one thing. So, this can be administered, I guess, by injection or?
Yes, the alternative means of administering are either orally or intravenous injection, and that's the 48-hour time frame, the time period that we recommended for that. But the topical application of the drug would be allowed on race day, and the principal reason for a difference is that there's very little of it from a threshold standpoint, and the amount of drug that you get into the body is very limited, what you can get through the topical application versus what you can get intravenously orally.
Okay.
All right, well, may I have a motion to adopt this rule proposal?
So moved.
Second.
All in favor?
Aye.
Aye. Any opposed? The motion carries. Rob, would you please call the next item?
Yes, for Commission's consideration is adoption of proposed revisions to the horse racing rules in relation to the cost and frequency of post-race testing of claimed horses to determine whether an impermissible drug or other substance was administered to the horse. A positive test result, of course, gives the claimant the option to void the claim. Adoption of this rule would discontinue the Commission's universal post-race sampling of claimed horses and replace it with a program of sampling at the expense of the claimant when the claimant requests this service on the claim form. The purpose is to eliminate the burdensome state expense of testing every claimed horse. Many claimants do not elect to avoid a claim even if their sample tests positive, and New York is the only major racing commission to provide unrequested free sampling of every claimed horse. Last year, there were a total of 5 post-race positives that results in claimed horses. With 4 of the 5 positives, the claiming trainer did not void the claim. Under the rule proposal, the stewards and judges would retain their discretion to order the post-race sampling of any horse at the expense of the commission. Positive test results for these samples would continue to provide a claimant with the option to void a claim. As mentioned when the commission considered this rule proposal, any cost savings relative to drug testing will be driven back into equine testing and research. We anticipate this amount will be approximately $270,000. The rule proposal was published in the New York State Register on November 18, 2015, meaning that the public comment period expired on January 4th. One public comment was received from the New York Thoroughbred Horsemen's Association. NYSA raised overall concern with the elimination of testing that they suggest has a deterrent value, but were supportive of the provisions that continued the steward's discretion, allows a horseman to voluntarily request a test, and enables avoidable claim upon a drug positive. NYSA further suggested that the commission should consider whether a positive test from an elective drug test paid for by a claimant may be used for disciplinary proceedings because the testing is conducted for the benefit of the claimant rather than to serve a regulatory purpose. Staff suggests rejection of this concept as any positive drug test has traditionally been central to the commission's mission of ensuring the integrity of horse racing competition and wagering. Staff does, however, anticipate that a positive drug screen test would trigger a fuller forensic testing at the Commission's expense. Staff recommends adoption of this rule amendment.
Commissioners, do we have any questions on the post-haste resting?
I don't recall. I know it came up before, but the savings of about $270,000, you're allowed to reprogram that?
$270,000, right?
Yeah.
Because it's part of the drug testing program right now.
Okay, and you,
So we will repurpose that for research.
Okay, so that's not taken for as DOB as the
Correct.
savings. Okay.
Correct.
Right.
until now.
No, no, no.
Anything else on this matter? May I have a motion to adopt this rule proposal?
So moved.
Second.
All in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Rob, would you be kind enough to call the next item?
For Commission consideration is item 4C is adoption of a proposal that would require specific minimum penalties for multiple medication violations. The proposal was designed to ensure that every state imposes a mandatory minimum penalty whenever a horse person, typically the trainer, reaches a certain level of multiple equine drug violations. At the heart of the proposal is the assignment of a specific number of points for each type of drug violation, along with a minimum mandatory license suspension based on the accumulation of such points within a specified time frame. The proposal is similar in concept to a suspension by the Department of Motor Vehicles of a driver's license when a motorist accumulates a total of 11 points in moving violations within 18 months. Points would remain on the person's license history for a period of time determined by the seriousness of the drug. Based upon how many points have accumulated, a licensee would be subjected to a minimum mandatory penalty enhancement of 30, 60, 180, or 365 days. This rulemaking is recommended nationally by the Association of Racing Commissioners International, and the concept has been supported widely by other non-governmental entities, including the New York Racing Association, the Jockey Club, and the New York Thoroughbred Horsemen's Association. This rule proposal was published in the New York State Register on November 18th, meaning that the public comment period expired on January 4th. 4 public comments were received, one each from NYRA, NYTHA, the National Thoroughbred Racing Association, and RMTC. Each organization fully supports adoption of this rule. Staff recommends adoption of this rulemaking.
Commissioners, any questions? I'd ask for a motion.
So moved.
So moved. Second?
Second.
All in favor?
Aye.
Any opposed? The motion carries. Rob, would you be kind enough to pull the next item?
Finally, for Commission's consideration are adoption of revisions to the Commission's horse racing rules that regulate the use of certain substances with per se thresholds and restricted time periods. The adoption of these rules would align the Commission's laboratory thresholds for controlled therapeutic medications with the latest ones approved by the Association of Racing Commissioners International. RCI recommends adding a threshold for albuterol, a bronchodilator, and lowering the threshold for ketoprofen, a nonsteroidal anti-inflammatory drug. Both recommendations are consistent with the Commission's existing time restrictions for albuterol and for nonsteroidal anti-inflammatory drugs that ensure a horse person will not inadvertently commit a threshold violation. RCI's Scientific Advisory Committee also recommended adopting 2 thresholds for cobalt, a dietary element. One threshold at 50 nanograms per milliliter regards detection of the intentional overuse of cobalt, a practice that has no valid purpose and cannot occur without using refined products. The second threshold at 300 nanograms per milliliter would impose a blood doping level penalty when a violation has occurred undeniably. Cobalt is reportedly misused in a manner that causes adverse effects in horses, including clinical signs of abdominal pain as well as a blood doping effect. Finally, the proposed rules would also add a threshold for isofluprednone, a corticosteroid, restrict its use to only joint injections, and establish a requirement that the Commission first warn a trainer whose horse tests in excess of the corticosteroid thresholds when the corticosteroid joint injection causing the threshold violation is shown in documentary evidence to have been administered safely in compliance with the Commission's 7-day restricted period for thoroughbred racehorses. Unlike other proposals, these corticosteroid rule proposals are limited to one breed because the Commission has different standards for them. This rule proposal was published in the State Register on December 2nd, 2015, meaning that the public comment period expired on January 19th. The Commission received 2 public comments, one from the New York Thoroughbred Horsemen's Association and one from the New York Racing Association. NYFA opposes the restricted time periods for albuterol and ketoprofen, stating that the Racing Medication and Testing Consortium has shorter withdrawal guidelines than the New York restricted time periods. Staff does not suggest amending the restricted time periods, as the proposal adopts the national thresholds for such drugs, which are consistent with the existing restricted time periods in New York. The second comment from NYRA expresses full support for the rule as proposed. Staff recommends adoption of these rule amendments.
Commissioners, any questions on the adoption of the per se thresholds and time restriction rules? All right, may I have a motion to adopt this rule?
So moved.
Second.
Second. All in favor?
Aye.
All opposed? Motion carries.
Before we move on to adjudications, which I think is next, can I just follow up with one question to Dr. Palmer? Is that all right?
Of course.
I was thinking about the answer that you gave me about DMSO. So if the issue is the I guess the blood level threshold that's implied by a topical administration versus like a subcutaneous injection or oral administration, why don't we just limit the threshold? Why does the manner of administration, why are we focusing on the manner of administration rather than just saying this is the threshold?
The threshold, the fact of the matter is that the topical administration of that compound has very little ability to influence the outcome of a race or really change the physiology of the animal. Whereas the intravenous administration of that drug in larger quantities certainly could influence the outcome of the race and influence the physiology of the animal.
But it's about the larger quantities,
That's
right?
Yes, and the route of administration. The route of administration, the amount of drug that can be administered at one time in one instance, and then that pharmacokinetics, the pathway, the way the animal deals with that, is very, very different than slowly absorbing it through the skin.
Thank you, Doctor. I appreciate it. Thanks.
All right. Next item on the agenda are adjudications. The commission has 3 hearing officer reports for consideration today. Mr. Williams, will you please outline the first case?
Certainly. Ben S. Joseph held conditional licenses as an owner, assistant trainer, and exercise rider. On December 4th, 2015, the Commission issued a notice of suspension and hearing following evidence that Mr. Joseph violated his license conditions. The hearing was conducted on December 16th, 2015. The hearing officer submitted a report to the Commission Secretary dated January 6th. The hearing officer recommended that Mr. Joseph's thoroughbred racing licenses remain suspended for a period of 1 year and that the licenses be reinstated, conditioned upon a showing that Mr. Joseph attended and completed an approved drug and alcohol program. At a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1, the Commission considered this matter.
The commission duly deliberated and considered this matter and determined upon a vote of 4-0 to both sustain and modify the hearing officer's report and recommendation, modified by adding, and upon restatement, such license will be conditioned upon random drug and alcohol testing for a period not to exceed, I believe we can agreed with 1 year? 1 year.
Not
Was that-
exceed or not less than?
Not less than 1 year, excuse me.
I think that's what we agreed.
Yes. The second matter is over to you, Rob.
On January 18, 2012, the Racing and Wagering Board issued an order to show cause why Jerome Palumbo should not be fined and barred from participating in racing in New York. The alleged grounds for discipline were that Mr. Palumbo trained thoroughbred horses in New York without a license, was responsible for a TCO2 drug positive for the horse Martha's Mandate on May 16, 2010, which ran at Belmont Park, and Mr. Palumbo had a history of prior violations and a conviction of a crime involving gambling and bookmaking. Mr. Palumbo had surrendered his groom and stable employee valid receipt on June 29, 2010. A hearing was conducted on June 12, 2012. During the pendency of the hearing officer's report being issued, Mr. Palumbo's attorney and commission counsel engaged in settlement discussions and reached an oral agreement in principle in December 2013 to settle the matter. Following delays caused by the applicant, a newly assigned hearing officer proceeded to adjudicate the matter on the basis of the 2012 record. The hearing officer submitted a report to the Commission Secretary dated November 22, 2015. The hearing officer found the charges were established by the Commission and recommended that Mr. Palumbo be fined $5,000 and be barred from applying for any New York racing license for a period of 1 year from the date of the Commission's decision. At a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1, the Commission considered this matter.
The Commission duly deliberated and considered this matter and determined that state law requires the appropriate standard to be used is preponderance of the evidence, and remands the case to the hearing officer to consider the record in accordance with this standard. Mr. Williams, will you please read the third case?
Certainly. This is in the matter of Roy Sedlak. On November 6, 2015, the Commission issued a notice of suspension and hearing to Roy Sedlak after drug testing indicated 2 horses he ran at Belmont Park tested positive for a prohibited drug known as AH-7921, or 3,4-dichlochloro-N-1-dimethylamino cyclohexylmethylbenzamide.
Oh,
I'm saying that only once.
Nice job.
Sorry, can you repeat that, please?
Easy for you to say.
Specifically, Mr. Sedlak, as an owner and trainer, was accused of running the horse Bossman in the 4th race at Belmont Park on October 11, 2015, finishing second, and the horse Literata in the 2nd race at Belmont Park on October 18, 2015, finishing first. A hearing was conducted on November 10, 2015. Mr. Sedlak was given the opportunity to have a prompt post-suspension hearing, which was conducted on November 10th, with post-hearing conferences held on December 2nd, 9th, and 16th to admit additional evidence in regard to potential penalties and to consider the correction of stenographic transcription errors. The hearing officer submitted a report to the Commission Secretary dated December 21st, 2015. The hearing officer found the charges sustained and recommended that Mr. Sedlak return any and all purse monies received from the 2 races in question, that his owner's and trainer's license be suspended for a period of 5 years, and that he be excluded from all New York racetracks for a period of 5 years. At a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of the New York Public Officers Law, Section 108.1, the Commission considered this matter.
The Commission duly deliberated and considered this matter and determined upon a vote of 4-0 to sustain the hearing officer's report and recommendations. So we move on now to any old business. I noticed there are 2 items on the list. Rob, at least 2?
Sure. The first one regards the staff report relative to KDE Equine. In November, staff issued a report in regard to allegations advanced by the People for the Ethical Treatment of Animals in regard to the practices of KDE Equine LLC et al. In large measure, that's Steve Asmussen's stable. In short, of the 14 allegations leveled by PETA, Commission staff found 4 allegations, which are not necessarily equivalent to regulatory violations, to be sustained. The evidence and allegations provided by PETA, an investigation thereof, and following industry-wide discussions, staff identified 9 regulatory measures for Commission consideration in 3 broad categories: furosemide, exercise-induced pulmonary hemorrhage, furosemide or exercise-induced pulmonary hemorrhage is the first, metabolism the second, and over-medication the third. In brief, the EIPH proposals would, by explicit rule, remove a horse from racing after it visibly bleeds, require disclosure of serious EIPH episodes to subsequent owners, and require endoscopic examinations following significant episodes of EIPH. Drugs whose primary purpose is to affect or modify metabolism would be restricted on the racetrack and not permitted within 30 days of racing, with special exceptions for horses with rare documented medical anomalies. Drugs would be restricted generally to a medical preventative or the treatment of a diagnosed medical disorder, according to the good faith judgment of the treating veterinarian. Veterinarians would be permitted to renew prescriptions based only on their own judgment. Trainers would have to keep a log of dispensed medicines that are administered by the stable. And finally, drugs that have the potential to cause a significant abnormal effect on the horse may be used only in the course of reasonable and appropriate use. In advance of the Commission consideration, these 9 rulemaking proposals were released to receive industry comment before entering the formal rulemaking process. As mentioned in November, this was requested to get the proposals out to the potentially affected parties more quickly and allow refining of the drafts before formal rulemaking begins. At our December meeting, the staff requested extension of the pre-industry comment period to gather some additional input. Today we have with us State Equine Medical Director Scott Palmer and by telephone, Assistant Counsel Rick Goodell. Both gentlemen were instrumental in undertaking the PETA investigation, drafting the resulting findings and report, and in the creation of regulatory recommendations.
Thank you both for participating today. To start, I'd like you to generally outline your communications with the racing industry and identify the issues and concerns that have been raised to date. Perhaps you could also identify a strategy for further outreach and discuss potential modifications to the proposals as written in the staff report.
Thank you. Be happy to. So as underscored by the Commission's comprehensive investigation, there are major challenges in modern horse racing that reflect core concerns of racing stakeholders and the general public, particularly those of abuse of medication. The New York State Gaming Commission is committed to addressing these challenges. The proposed regulations are designed to address concerns with exercise-induced pulmonary hemorrhage, known as EIPH, the use of specific drugs or types of drugs, such as thyroxine or similar substances that regulate metabolism, and the general concern we all have with protecting horses from inappropriate overuse of therapeutic drugs or the use of non-therapeutic drugs and other substances with potent effects on the horse when horses involved in horse racing. These proposals are intended to enhance the integrity of the sport and protect the horse. These proposals are also part of the broader Commission goal to improve equine health and welfare. The concern regarding the abuse of medication racing is not a new one, and it's not unique to New York State. Our goal is to ensure that all medication given to racehorses is first and foremost for the benefit of the horse and administered in a manner that is consistent with quality veterinary care in the context of a valid veterinarian client-patient relationship. The pre-publication comment period has been supportive of the Commission's goals and has also provided the Commission and staff with a number of helpful comments and recommendations to improve these rule proposals. The primary area of concern has related to vagueness and uniformity in these proposals. These concerns are natural when one considers that any novel medication regulatory philosophy that is designed to address fundamental challenges of effective regulation of a rapidly evolving medication landscape is involved. Regulations designed to prohibit the use of specific medications, by their very nature, will always lag behind the introduction of new medications in horse racing. The proposed regulations are designed to prohibit general medical practices that are intended to enhance performance in the absence of a valid medical indication related to horse health. We have solicited and received both written and oral input from interested stakeholders, including regulators in other racing jurisdictions, the American Association of Equine Practitioners, the Association of Racing Commissioners International, and other reputable organizations to develop optimal language for these rules. While the objectives of this rulemaking are simple, we realize that the rulemaking language is difficult to construct, particularly the definition of medically unnecessary treatments. But this is an effort to move forward as an industry to address this important problem. We have been soliciting, encouraging, and we continue to solicit conversation with our colleagues throughout the industry. The adoption of the National Uniform Medication Program represents a very meaningful and positive step forward to control the use of specific medications given to racehorses in the days leading up to the race. Our proposed rules are intended to operate in concert with the National Uniform Medication Program to regulate medication usage in a purposeful manner defined by the specific medical needs of the horse. If you like, I'm prepared to briefly review each of the 6 specific proposals from a strategic perspective.
Sure.
I'll start with exercise-induced pulmonary hemorrhage. These rules are designed to define the terms of ineligibility to race after episodes of epistaxis, which is bleeding from the nostrils. These rules will require disclosure of episodes of epistaxis to subsequent owners of horses when the horse is sold or claimed, and will also require endoscopic examinations after episodes of epistaxis. Equine pulmonary hemorrhage is a common and important condition of athletic horses, and the control of EIPH has long been at the heart of controversy throughout the racing industry. These rule proposals are specifically designed to provide increased protection for horses that experience epistaxis, the most severe form of pulmonary hemorrhage. Although epistaxis is extremely rare at New York racetracks, approximately 1 episode per 2,000 starts, it is a significant health risk to the horse, and repeated episodes cause progressive lung damage. Severe episodes of EIPH can eventually lead to sudden death on the racetrack. Written oral comments are mainly concerned with uniformity and compliance. New York pursues uniformity through leadership and proposing amendments to the RCI model rules, and we do not foresee any negative effect on New York racing from our leadership role. The potential lack of compliance for ship-in horses, for example, can be addressed by the proposal for a model rule to this effect. The rule's requirement of disclosure of serious previous episodes of exercise-induced pulmonary hemorrhage or epistaxis would only apply to a horse after it changes hands, which is to the advantage of all racing participants and in particular the horse. NYRA proposed that the Commission use our ESAL reporting system as a vehicle to store this EIPH information, and the Commission staff agrees with this. I can continue.
After?
After. Yeah.
Why not when?
Well, there's concern about the proprietary value, or the confidentiality issue of a horse's health care. As long as the owner is consistently owning the horse, he should know that the horse had an episode of this.
And the public, that shouldn't be disclosed?
We don't feel it's appropriate right now to do that.
I disagree. I mean, you said what percentage of horses end up exhibiting?
1 in 2,000 starts.
Right. I mean, if that's still the number, what are we talking about?
Very few horses.
But it is relevant as a condition, no?
Yes, it is.
What? Yeah, I don't understand why there's a need for confidentiality.
Well,
Maybe I'm not seeing.
Can I interject? This is
Sure.
Rick.
sure.
When epistaxis is observed, it's readily apparent, and it does lead to mandatory periods of time in which the horse can't race. But there are less serious episodes of exercise-induced pulmonary hemorrhaging that are also covered by the rule proposal. And those are the ones that would not necessarily be disclosed publicly, but as a first step towards better care for the horses, this rule proposal would require that at least the new owners are always informed when there's been a serious episode.
Is that for all 3? There was 4 levels of bleeding, right, doctor?
Yeah, there's more than that. Actually, but the 1 through 3 are believed, in recent research, as we talked about this summer, are believed to be significant, but not necessarily going to cause a long-term ill effects on the horse's performance or his general health. But 4 and 5, the more severe ones, do. And so that's why the primary goal here was to make sure that a new owner of a horse knew that episode occurred so that he could appropriately manage the horse. Without that information, you may remember a testimony of one of the trainers this summer that talked about a horse that he got from England. And they sent him over here to be trained and didn't tell him the horse is a bleeder, and the horse had some real problems as a result of that. And so we're trying to address that situation.
So he said, right?
Yeah.
It seems inconsistent, doesn't it? That you would only disclose it to the new owner after after it changed hands? Why wouldn't that be valid information for the gamblers at the track? It's a fairly serious condition. If you exhibited it, you're not, you're in a 1 or 2% range of horses, right?
Less than that.
Okay. I mean, so wouldn't it seem more relevant to tell everyone this occurred?
Well, as Rick said, the horse would go on the vet's list, and that's information.
But you can go on a vet's list for any number of things, right?
sure.
You know, your ankle, your toe, your tongue. I mean, they get sick. There's levels of being sick, right?
This is Rick again. One of the consequences of being on the vet list is that the horse not only cannot race for a specific minimum period of time, but that the horse also is not permitted to race until a veterinarian, independent of the stable, releases it to race. So that would be the protection for the betters.
Pretty flimsy.
So,
No, it really is. I mean, when you think about it, it's like saying, well, you know, if the vet clears you, you're fine. But, I mean, you could get a clean bill of health after a physical, or, you know, you could be like a cancer survivor and get a clean bill of health. They mean different things. The doctor said I'm fine. I don't know that standard actually works if you're relating to an incident that is, you know, more than 2 standard deviations for the norm in terms of its impact.
Well, I think your point's well taken. We should take into consideration as we go forward. Remember, these are all pre-proposals, and you know, your comments are certainly valid and appreciated.
So the process then is the publication of these?
Well, we're still gathering information. We're not
Okay.
even at the point of publishing these things yet.
Fair enough.
Yes.
Okay, sorry, go ahead.
So, level of detail's okay to go ahead with that?
I mean, I think it's a bit much. I mean, we keep going through them. It's a lot to digest here in this meeting. I don't know how you guys feel, but
One suggestion I would make is I'd like to see what the industry says about your proposal about releasing the information sooner, prior to the sale. I mean, if you just put out the proposal the way it is, we'll never know what the reaction would be to
fair
what
enough.
you're
Yeah,
saying,
yeah,
John.
yeah. And what level of bleeding is the relevant one to detail? To your point, or to the point others made, they all bleed at some level, but there's a big variation from a little bit of blood to more severe Category 4, Category 5
Right.
bleeding events. So
Well, how would you propose that this be noticed to the gamblers at the track?
they find it. The vets find it, right?
Right, and then-
it's evidence of it. But I mean, I guess if there's 5 grades of it, I'm not sure what grade is the relevant one. Certainly 4 and 5 would be, you know?
Epistaxis, the good news about the concept is that epistaxis is easily identifiable. And,
Right.
you know, there's not a lot of controversy about, you know, the horse theoretically could bang its nose on the gate, coming out of the gate, but that's even a more remote possibility. So,
Sure.
you know, if a horse has epistaxis on the racetrack, it's documented by the racetrack veterinarian.
Mm-hmm.
And that's a very significant event, no question about it. And it's much more significant than the lower grades that we talked about earlier. So that would be the level of demarcation, if you will, in terms of where do you draw the line.
Category
in terms of what you
4?
gotta report. Mhm.
Yeah. Yeah. It's worth hearing if you're in a public comment period, what people would react to that.
Well, we're not in a public comment period. We're still gaining
Okay, all right.
But yeah, so we can ask that question and get responses to it.
Good.
Yeah. And I guess to what level would qualify towards making it known that the horse bled? Right? To your earlier point, they bleed in every race.
No.
I'm not sure, well,
For the most part,
right,
to some degree.
to some degree. But there's levels, and you've, as an industry, have made determinations about which level of bleeder they are, right?
That's right.
2, 3, 4, and 5. So, I mean, I don't know what the right standard would be, but 4 and 5? 3, 4, and 5? I'm asking.
We're looking at 4 and 5.
Okay. Yeah, seems reasonable enough.
We did receive some public comments from NYRA and NYSA expressing concern that some of the trainers and veterinarians would not disclose the EIPH incident and would
Understated.
purposely not comply with a rule that is too broad. So the points are well made, and we are considering those, as the industry is as well. And we're also concerned to make sure that the rulemaking proceeds in a way that will be well received and complied with.
Who scopes
I
the
think
horse?
there is a broader issue, though, as well, about whether all veterinary records and information shouldn't be disclosed. And that
Yeah.
certainly is a big debate as well.
Sure. Who scopes the horse?
Private veterinarian.
Private? So, I mean, they make a determination when they scope it, right?
Of the degree of bleeding?
Sure,
Yes,
or
absolutely.
any bleeding, and then the degree of bleeding, right?
Absolutely.
So why can't that be the trigger? Everyone gets their horses scoped, right?
No,
Or looked at after a race if they think
Not
something's
always.
not run right? Well, okay.
depends on the trainer.
Many decent trainers, when the horse doesn't perform according to what they had anticipated, or the horse evidences some inability to put his A game forward, getting him scoped is sort of a first measure before they. Do we think that would stop somehow if there was a more complete reporting function? Is that what you're saying, Rick?
No. But really, it would be that not that it wouldn't be accurately reported to the trainer by the veterinarian, but rather that they would be resistant to accurately reporting it to the public.
The trainer would be?
The vet.
That was the concern that was voiced by in the public comment,
The
the
vet.
pre-proposal comments that we received both from NYRA and from NYSA.
Doesn't the vet operate on NYRA grounds and others as a condition of NYRA allowing them to?
They have authority over them without a doubt.
So,
We have discussed, John, also the concept of whether under certain circumstances we would want a NYRA veterinarian to do the scope or a regulatory veterinarian. Scott's informed me that that's pretty challenging to do, but it's something that we're also taking a look at.
well, I don't want to delay it. I mean, if we're just seeking comment.
Okay?
Yeah?
Okay, the trainer's log regulation, proposed regulation, is intended to require trainers to keep an administration log of all dispensed medications given to horses in their care. Currently, there is no requirement to document the date and dose of medications when administered, typically in the feed, to racehorses by trainers or lay employees in the stable. The intent of this rule is to require record keeping for the medications given to racehorses by laymen at New York racetracks. Public comments recommended clarification that this is simply a record-keeping requirement and does not alter current industry practice regarding drug administration, and that this requirement does not apply to treatments administered by a veterinarian for which records are already made. Staff agrees.
Sorry. Keep going, sorry.
Renewal of prescriptions. Veterinarians would be required to renew prescriptions based on their own medical judgment. When renewing a prescription to avoid withdrawal symptoms, a veterinarian must prescribe an administration schedule that eliminates dependence upon the drug. Currently, veterinarians may be asked by a trainer to renew prescriptions for medication previously prescribed by another veterinarian that may no longer be clinically indicated, but will do so to avert withdrawal symptoms. For example, daily administration of hormones such as thyroxine or corticosteroids will suppress the body's own production of these hormones. An abrupt withdrawal of these treatments can cause health consequences for the horse until the normal hormone production by the body is restored. This rule will require that the renewed prescription include directions for withdrawing the horse from ongoing use of the drug and thereby end this practice. Public comments. There were no comments from horse persons or NYRA or Finger Lakes at this point. During the November 30th meeting of the Association of Racing Commissioners International, a member of the Drug Testing Standards and Practices Committee questioned whether this rule was necessary. On the basis of the findings of the Asmussen investigation, this scenario was confronted by New York veterinarians who felt more thyroxine was appropriate only to avoid withdrawal issues and resulted in the continued daily administration of thyroxine in the absence of current re-examination or evaluation for the need to give this drug to treat hypothyroidism. Metabolism modifying drugs. A horse may not race for at least 30 days following administration of these drugs. No person other than a commissioned veterinarian, track veterinarian, or practicing veterinarian licensed by the commission shall possess these drugs. No drug shall be administered to a horse except based upon a specific diagnosis and prescription for such by a treating veterinarian. And it shall be an affirmative defense to a violation of this section that a person possessed or used such drugs only in a time, place, and manner specifically permitted in writing by the Commission. This rule is intended to eliminate the unnecessary administration of metabolism-modifying drugs to increase metabolism of racehorses in order to enhance performance. Written and oral public comments were mainly concerned with whether the rule might be too broad. NYSA asserts that a horse with low T4 levels benefit from a small dose of thyroxine. Staff notes that leading experts all agree that low T4 levels is not sufficient indication for daily thyroxine supplementation, and the drug is rarely prescribed or used by a majority of trainers at New York racetracks. The provision for use with advance notice and permission by the Commission should control the possible misuse of this drug while permitting typically short periods of treatment that may be appropriate. Staff agrees that further study of substances in general that may or may not manipulate metabolism as a primary purpose or effect is indicated. To address this concern, we will work closely with practicing veterinarians and leading scientists to add specific examples, such as thyroxine and similar substances, and to ensure that the proposal's wording is both sufficiently broad and precise and clear. The ARCI Drug Testing Standards and Practices Committee offered that certain substances used to regulate female reproductive cycles might influence metabolism, for example, and should be clearly excluded from this rule. There is wide interest among jurisdictions in finding the best means to regulate the use of thyroxine in their jurisdictions. Staff will continue to enlarge and intensify its review of specific examples of metabolism-modifying substances and reach out to more regulated parties both in New York and in other jurisdictions for additional output.
Has a gender impact?
No, it doesn't. No, but there's certain, Regamate is a hormone that's administered to females, fillies and mares, to stop their estrous cycle while they're racing, and that can arguably influence their metabolism. So it's going to be important to make some distinctions about some of these treatments.
Does that happen fairly regularly? The first treatment to stop their cycle, that's a normal?
Well, it's very variable. In some mares, it's not a big deal, but in those mares, when they come into heat, when they're in training, it can be a huge problem. So, yeah, it's a pretty common indication for that medication. Over-medication. No drug should be administered to a racehorse except as either a recognized preventive or as an accepted clinical treatment for an existing medical disorder or condition, as would be appropriate in non-racing circumstance. For example, any therapeutic drug given without medical need or indication. This rule is intended to prohibit the administration of drugs to racehorses in the absence of an actual medical disorder. Written and oral public comments voice concern that this rule may be overly vague and suggest further consultations with the RCI and the RMTC. Staff agrees that further input will be helpful, including comparison with other rulemaking by the Veterinary Practice Rules and Guidelines of the New York State Department of Education's Office of the Professions, which licenses private veterinarians. A member of the ARCI Drug Standards and Practice Committee compared this rule to hay, oats, and water. This reflects a misunderstanding or misinterpretation of the rule's intent and meaning. Staff will continue to examine the wording of this rule to clarify the intent and meaning and to seek input about how to draft a rule of broad application that prescribes the conduct of administration of drugs to horses in the absence of an actual medical disorder. Finally, the abuse of potent substances. No drug or other substance that could abnormally affect, and that means alter the normal physiologic processes of, a horse should be administered unless in the course of reasonable, good faith care of the horse. Within these restrictions, these proposals would not second-guess the documented professional judgment of treating veterinarians. An example of this is cobalt sulfate. Initially, we did not have an adequate rule to regulate cobalt in New York, so if we put this kind of rule in place, when the next new potent substance emerges in racing, we will have a rule in place to address it promptly. This rule is intended to prevent the administration of drugs to horses that have no accepted therapeutic use in the horse and can have harmful side effects. Written and oral public comments are mainly concerned with vagueness and uniformity. Staff agrees and will work on to be more explicit in identifying what drugs and other substances are addressed by this draft rule. In particular, additional language is being considered to narrow the rule to substances that are capable intrinsically of abnormally enhancing or impairing performance and are non-therapeutic as used. In conclusion, the pre-publication comment period has provided the Commission staff with a number of helpful comments and recommendations to improve these rule proposals. Staff will continue the dialogue with industry stakeholders to refine these proposals prior to presenting them to you for approval. Our goal is to provide for the use of medication in an era of advanced equine sports medicine with a focus on the medical needs of the horse as a top priority and delivery of medical care that defines the highest standards of professional integrity and ethical practice. We will be working hard and cooperatively with industry stakeholders and other regulators to overcome any concerns with vagueness and uniformity, and to provide an optimum rule proposal for our medication regulatory philosophy that is designed to address the fundamental challenge of effective regulation of a rapidly evolving medication landscape. As I noted at the outset, regulations designed to prohibit the use of only specific medications by their very nature will always lag behind the introduction of new medications into racing. The proposed regulations are designed to prohibit general medical practices that are intended to enhance performance in the absence of a valid medical indication related to horse health. We will address these issues in the upcoming months and are encouraged by the support in principle for all of these proposals.
Sounds great.
Thank you.
Thank you very much. That was
Thank you both.
very thorough.
A lot of hard work went into this.
More to
Really,
come.
really appreciate it.
Okay. The communication, you did this already, right?
Yeah, we're up to whip research.
Whip usage, yeah, excuse me. In November, following the adjudication that involved the use of a riding crop, commissioners requested staff conduct research into the use of a whip in jurisdictions across the United States. As you are aware, late last week, legal circulated a memorandum detailing their research. While we understand that all commissioners may not have enough time to fully digest the information contained to discuss the issue and its potential variations, I'd be remiss if I let this opportunity pass. So, thank you for preparing this, putting it together. Today, I've been informed we have Thomas Kennedy of Kennedy, Jenick, and Murray, who serves as outside counsel to the Jockeys Guild, and Jeff Johnston, who's the regional manager with the Guild. You here?
Yes, sir.
Oh, hello.
Hi.
The Jockeys Guild has been involved with California's recent attempts to revise their crop rule, and perhaps they would give us some of their comments and experiences on the landmines and concerns from their experience and what to consider in existing rules. If you'd be so kind.
Thank you. As the chairman noted, my name is Tom Kennedy. I'm the general counsel for the Guild. With me is Mindy Coleman, who is counsel for the Guild, and Jeff Johnson, who is our regional manager, one of our regional managers. We have prepared a presentation to the commission that I'd like to distribute, if I might.
Sure, yeah.
I have 11 copies. Hopefully that'll be adequate. We'd probably find out.
You'd sit down if you're more comfortable.
And my role today is really just to introduce Ms. Coleman and Mr. Johnson. Mr. Johnson's was a jockey for a long time, has more than 15,000 mounts, many of which he won, but not all.
Thank you.
Come on down this way. Thank you.
Thank you, commissioners, for
Excellent.
being able to participate today.
Do you want to put him, we can put
Actually,
chairs
why-
here for these.
Get back to the, why don't you come over here, Scott? You want to, Scott and I will move down.
Closer to the commissioners.
Again, as Tom said, my name's Jeff Johnston. I'm the regional manager for the Jockeys Guild. My region includes Kentucky, Illinois, Indiana, Ohio, Iowa, Minnesota, New York, and New Jersey.
Oh, wow.
Commissioners, for years, the horse racing industry has been looking for ways to maintain or gain market share in the sports, entertainment, and gambling industries. One of those measures has been to look at public perception, specifically the use of the whip. Several years ago when this first came out, one of the things that we did as an industry was change the rule, or changed even the wording. Whip is no longer used. It's taboo. It's now a riding crop, and in that process, the dimensions and aspects of the whip were changed. It's no longer as severe as it once was. It's now a padded riding crop that is much less severe, much easier on the horse, much more humane. It was mentioned during this time period that why don't we just do away with the whip? Well, that's not an option. As far as the jockeys are concerned, this is a tool. It's a safety measure. It's a necessity in the racing world. It doesn't have to be severe, but you need something that's going to get the horse's attention if they're doing something that is harmful to either you, the other horses, or the other jockeys in the race. Also, upon implementation of the riding crop rule, there were other measures that went into it, including the vets were supposed to or are supposed to check after each race to make sure that the horses are not being cut up or welts being put on them. That the riding crop is actually doing what it's supposed to do, be less severe and be more humane for the animal. Recently, however, there's been, because of the riding crop changed and it's padded, it makes a louder sound. So even though it's a softer whip, it's more humane, it sounds worse than the old ones. So we still have a perception issue, and it's not been really marketed well to the public to say that we're even using these. They still think that it's the old severe riding or whip. So one of the things we can do, I think, is start a marketing campaign, explain to the public or the fans that this is easier on the horse, that it's certainly not as severe as what it sounds or looks like. But other states have looked at new rules, basically limiting the number of strikes or asking the jockeys to hit the horse on a limit of 3 times and then give them a chance to respond. This works relatively well, especially as an awareness campaign to the riders to make them think of how they're using it, to actually say, hey, consider the fans' point of view. You know, if you don't need it, if you're winning by a lot, you don't need to pound on the horse. If you're out of contention, you don't need to pound on the horse. But states are still looking at ways to amend that rule and make a rule that limits the use of strikes. They've done this in California. It's been in place for a year or so now. They've had multiple problems with it. They've also done it in Illinois. They've had multiple problems with it. They've got a house rule that they implement in the Chicago area tracks, and they've had multiple problems with it. The problems being, one, the fines can get pretty severe if riders have multiple violations. But the bigger problem is it's not a good rule for the bettors who we need in this industry. When it comes down to the wire and you're restricted to use the whip 3 times instead of 4, and a rider's been fined multiple times, he's not going to use it. While the guy next to him hasn't been fined, he's going to take the minimal fine, the first fine, in order to win the race and get the share of the purse. Well, who loses there? The guy that stuck with the rule. The guy who was true to the rule loses the race. The owner loses the purse. The trainer loses his percentage, and the people that bet on that horse lose. The people who broke the rule win. So there's been multiple problems. We've gone to California. The jockeys have set up, asked the commission or the California Racing Board to set up a committee to look at this rule. The stewards at NYRA have contacted our office, our national manager, Terry Meeks, and asked that we help them, or they wanted to implement the California rule, and we've asked them, with the addition of a petition signed by the NYRA riders, to hold off on adopting the California rule because it did have so many problems, and work with that committee to basically come up with a rule that gets done what they want to get done, but doesn't harm the participants or the bettors.
Is there a limit?
There is no limit, actual one number limit.
But you're a rider. Is there a limit? There's a number of times that you say, well, look, more than this, it's just too much.
It depends on the horse, and another problem with this rule is it's not every riding crop strike is created equal.
Mm-hmm.
There are riding crop strikes that are very severe, very high above the head, very hard, very strong riders that really get a horse's attention.
Mm-hmm.
Really, one or two of those should be fine, but there are other horses, especially horses in my case that I remember riding, that came from way back. They were lazy horses.
Mm-hmm.
They didn't require to be hit hard. They just required motion or movement. So in the case of, you really, it's a tap. It's not even a strike. It's a tap, but it's the tap, 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 tap. If you get let up, they're going to let up. So it's not about how many. It's more about how severe.
The way this came to us originally is when a jockey dropped the crop and used his goggles. Do you have any position on a rule that would limit jockeys just to use a crop and not use anything else?
Well, first, the goggles aren't going to harm a horse. It's, again, accidents happen. You can get your whip knocked out of your hand by a rider.
So you think we should allow them to use their goggles?
I think so. They're not going to do it. The goggles aren't going to do a lot. They're not going to influence the outcome of a race necessarily.
We did debate it a little bit, remember? Because on the other hand, to your point, if he didn't use everything he could to get the horse up, maybe it's a subpar effort to not get everything he can from the horse to run. I mean, if you were better.
Point on that, Mr. Chairman.
Please.
Our research indicates that there have been 4 times under the ARCI database since 1987 where jockeys have been fined for using goggles, if I got that right.
The last time it was actually done in New York was 1987. There's 4 times period that they've.
Well, we did it last year.
No, up until.
Up until that, it was 1987?
Last month. It was 1987 with the New York racing, and it was Randy Romero. Then, up until that time, last year, it was inconsistently applied in the state of New York. There were 2 jockeys that were fined. There were 4 others that were not fined. And that's when it was brought to everyone's attention at this point with the goggle issue. But on a regular basis, I mean, jocks across the country have dropped their riding sticks and used goggles or other means, helmet covers to.
Are there any states that do limit it to just the crop?
I'm not sure. States' rules and regulations vary from state to state, and a bigger thing would be implementation. Usually, if you've got a good stand of stewards, they're gonna hold the best interest of the horse and the public at hand. If the jockey's doing something that's going to harm the horse or the integrity of the sport, they're going to get penalized, even if it's in the rule book. But I'm not aware of any states that have a specific rule that say you can only use the riding crop.
Are there any states that any of you are aware of that we should look to as a model?
On this point?
Yes.
With regards to the goggle, there isn't anything specifically.
Just on crop use in general.
Crop use in general, we're in the process of trying to come up with the model rule as far as what should be done, and that's kind of what Mr. Johnston was alluding to with the striking issue. That's where the model rule's been directed. There hasn't been anything with regards to the goggle issue until it came here in New York. There was one case, and it was in, correct me, Illinois or Ohio.
I want to say Ohio.
It might have been Ohio, where they had done, and they had given the jock multiple warnings, and that was out. That situation. A lot of times, if the stewards do believe there's an issue, they typically give the jock a warning, say, hey, don't do that. If they think that it's the jockey's fault, but most of the time, like Jeff said, a jock doesn't want to go out there without their riding crop. They would prefer to have if the horse responds to a riding crop, they're going to prefer to have it. Now, there are states where it does vary is whether or not you're required to carry a riding crop. There's one state where you're not required, or you are required to carry it. Other states you're not required to carry it, and if you do not, you're to be disclosed to the betting public.
If I recall correctly, I think in the case that you adjudicated recently, the hearing officer referred to a rule in Colorado that explicitly said the only thing that you can use to strike a horse during a race was a riding crop, and he used that as an example of what we don't have in New York. So I don't know if that's something that,
I was trying to remember if it was Colorado or Ohio, there might be one.
Ed, didn't you give us a survey of crop rules?
Yeah.
I did, it was all, but it wasn't just with regards to the goggles, it was,
It's more about the whip.
oh, I'm sorry, I thought you had resubmitted it.
It probably was a lot of
We
your stuff.
received materials from the Jockeys Guild, and we forward that on. They've been incorporated in the materials that were
Well,
circulated.
do the jockeys have a standard they want to see enforced? I mean, if you're sitting at the table with these things, you obviously have a path you want to get to, right? Or a standard that would work for you as well.
I mentioned this one piece, that I think on goggles, our position is it's a problem that comes up so rarely, it doesn't need a...
I agree. I'm not asking about goggles.
I think he's talking more about the crop.
The crop, yeah. I
We
mean,
have made a proposal that we actually described in our presentation
Okay.
to the California committee that's reviewing this. And I want to note, because I think it's significant, that when the rule went in California from July 1 through November 11, there were 125 fines handed out with 13 suspensions for 69 different jockeys. That's why we came to California and said this isn't working. The 3 strikes and then a pause wasn't translatable apparently into the racing world. And my understanding of what we're looking toward, although we would agree that we want a consensus rule that the commissions are comfortable with, the public is comfortable with, the bettors are comfortable with, and that's something we think is a process. But the 2 problems we have is that we think the mechanical application of a limit doesn't address instances where a horse is either lugging in or getting out, and the jockey, for safety reasons, has to simply respond. And it doesn't address the what we call the final 16th of a mile issue, where you should be urging the horse under the normal rules of racing as dramatically as is necessary for the horse to finish well. That doesn't excuse somebody beating a horse up, and if there's evidence that that's happened, then they should be appropriately disciplined. But we think a mechanical rule fails to address the points I made.
and as to safety, it would seem fairly simple that if you were a jockey and you exceeded whatever the limits were, and you felt like you were in danger, so you had to use the whip exceeding whatever had been sort of set as the limit, you would simply state that, and there would be some amount of, we do considerations of these matters all the time. You'd say, well, I was in trouble, the horse was coming in on me, I wanted to keep him away, so I gave him a couple taps to get out of trouble. Sorry, it's over the limit. And then there's a determination to be made. It's to the last 16th mile, maybe the horse is just slow.
And if I may, that's currently with the model rules and some of the language. It says it has a steward's discretion, and there's determinations if a jockey is abusing the horse or an excessive use of the whip. And again, we go back to the state that's inspecting the horse after. So I guess some of the modifications aren't necessarily required, other than we're doing it for public perception, and that's why when we were approached by the CHRB initially in 2014 to create this, we said, okay, look, we'll do 3, count 3 times and give them an opportunity to respond. What we considered the opportunity, or jockey considered as the opportunity to respond, and now what's being interpreted as the opportunity to respond, are turning into 2 different things. But again, we agree with you. We want it to be at a discretion if it's a safety issue, whereas this is turning into a literal interpretation. And so you have 1, 2, 3, and then that's it. It doesn't matter if the horse is lugging in or out or the reasons.
And one point I would make in response to your comment, Commissioner, is that I think what you're saying, of course, makes sense. But if the default position is there's automatic discipline on the 4th strike, if there hasn't been a full stride in between, and then the jockey has to accept the discipline and then respond to it and then offer their defense, I think that's unnecessary imposition on the jockey. I don't think we'd have a problem with the idea that the stewards have the discretion to impose discipline if someone goes above 3 strikes before the before the horse has a chance to respond, recognizing that the last 16th of a mile is one issue and the lugging in, lugging out is another.
So you said there was a proposal in here, and what you distributed?
We described in sort of
Okay.
prose what we gave to the CHO.
Be good to take a look and see what's in there.
And what we've requested is with Mr. Goodell and working with Rob, that we work in conjunction with the committee that's currently working with the CHRB, so we can get some sort of uniformity, because obviously once New York and California adopts it, then everyone seems to follow suit, and we'd like to have, as Mr. Kennedy was indicating as well, uniformity with this
Sure.
rule. So as opposed to it going into effect immediately January, or going into effect this month, that we would have it.
I don't think we have a rule on the table, do we?
And she's referring to a House rule that Naira had proposed.
Oh.
Which may or may not be preempted by commission action already on the subject. It's something that we're considering.
We would like to be able to advise our members that there is intense interest on the commission and by NYRA on the use of the whip, to urge them in an informal way to recognize that as they ride, but for there not to be a formal House rule in place until we regularize this topic, which we're happy to work as quickly as you want us to on.
Chairman, may I ask Jeff a question, please? Could you give me your feeling about timing of applying the crop? You know, when you, in the horse's stride, I mean, in terms of, do you feel that there is a opportune and, by contrary, an inopportune time to strike a horse during its stride to achieve the desired effect of urging the horse to move forward?
You certainly have to be in rhythm with the horse and hit him in stride. Hitting a horse that's already trying as hard as they can be counterproductive. So you really have to read the horse. You have to hit him at the right time. There's other times when a horse will kind of be tripping all over themselves. There is no regular stride, and a good whop of the riding crop will kind of line him out and make him extend himself where he's going on again. But mostly it's just feel. These guys are professionals. You have to just give them the chance to ply their trade, and they don't want to hurt the horse. None of them do.
I appreciate your comments, but in my conversation with some very good jockeys, they've told me that there are inappropriate times in the horse's stride to hit the horse where you actually distract them or may upset their stride, you know, in terms of how you apply that. It's not so much I realize it's an art form too. It's not something you can, you know, restrict. I'm just interested to hear your comments. Thank you.
Yeah, it'd probably be a good thing also, maybe, I don't know if it makes sense, but dollar levels. You know, the grade 1 races, graded races, the black types, it's a different standard than, you know, $10,000 state bred. It's different exercise of the use of the whip in general, right?
It shouldn't be. It should be a uniform application of what
I don't ride the horses, and just, you know, observing them, there seems
You're
to
talking
be
use of the whip as
yeah, there
opposed
seems to be
discipline.
more encouragement required at the sort of lower claiming rungs than there does at sort of
Required or just applied?
applied. Well, probably both, but I mean, at some level, who's to say? They certainly don't run as fast as the horses in the bigger stakes races and bigger allowance races. Just something to consider, I guess. You're a jockey. You've run from the top to the bottom. Any validity to that? I mean, the quality varies greatly by race, right?
Well, and again, it comes down to the individual horse. One of the best horses I rode required a lot of...
Which one?
It was X-Country. He ran in the Early Times Classic on Derby Day.
Okay.
But he was a lazy horse that laid back, and when you moved on him, you had to stay busy. It didn't take a strong hand, but it took a frequent, you know, just that constant movement. Whereas I rode other cheap horses that loved to run, and some of them, if you hit them, they would, like Doc saying, that they would back up on you. So you really have to. It's now they weren't talented. They weren't as talented a horse, but they had the effort there. So it's on an individual basis, and it's really that's why it's so hard to make one rule with how you can use the riding crop, because it's going to affect certain horses and it's not going to affect others. And it's really, in this case, more about the humane use of the riding crop and using it properly.
So I guess we'll look forward to hearing more from you and reading what you've put out there, right?
There's one other matter that Mr. Meeks, the National Manager of the Guild, asked us to raise. I'll just mention it briefly. There's been some discipline in New York as a result of flicking or fanning a horse's ear as a means of encouragement, or sometimes, frankly, accidentally as you're moving forward with the crop in hand. And we believe that discipline for that, in the absence of some evidence that the rider is trying to hit the horse or that the horse visibly reacts. I think we'd even agree that if a horse is hit on the head or the ear with enough strength that their head moves, as I've seen before, that's could be a subject to discipline. You're not supposed to be hitting the head of the horse. But if you're showing the horse the crop, it's very difficult to sometimes not flick their ear. And the idea that you'd be disciplined for that, in our view, is just lacking what I would call race sensibility. So I don't know, Jeff, would you have any comment on that?
Well, there's different riding styles, and this is one that another humane effort to get the most out of a horse that doesn't harm the horse. By laying the stick up like between his ears, the horse will actually put his head down and extend his stride more. So even, I don't know what is considered, where you draw the line between flicking a horse's ear and doing something that should be illegal or punishable.
That was a recent adjudication, right? We had last. Yeah, but the problem was
the goggles case.
No, was it? It wasn't. It was the whip hit the guy. The whip hit the horse in the head.
Yeah.
The whip. He was holding it.
Oh, he wasn't
different.
striking
He
him on
wasn't
the
flicking
flank.
him.
Yeah.
He was hitting him in the head, and the rule was pretty clear as related to the whip in the head. I think that's what that one came down to. I don't know. I don't think it was a flicking in the ears, but maybe we're thinking about a different case.
The hearing officer said it was actually a flicking of the ear, but they took the interpretation of the ear to be part of the head, and you're not to strike the.
Was he flicking it with the whip?
So when a jock's down riding and their hand, the riding crop is going like this, it was doing this in his ear, and that's what they were considered hitting. That we went back and watched the video, and they'll fan an ear to make that sound in the horse's ear.
He hit the horse in the head with the whip. He did, and that's why we found it. I appreciate your opinion,
Well, I
but
think we agree then.
yeah, I
If
mean,
it was just ear flicking. Our point is that shouldn't be.
I would agree with you, but he hit. It was inadvertent, I think, by even the hearing officer, but he used the whip and hit the horse in the head. I mean, you've studied the case. I don't recall all the details, but I thought it was one of those sort of cases you read and go, well, unfortunately, we're going to find it against them because it was perfectly clear you cannot whip the horse in the head under any circumstance.
I mean, if you want us to consider some language, that would make the regulation clearer that it's not going to cover incidental contact that does no harm to the horse. If you want to suggest some language.
Mr. Medell is listening to the call, and the Guild has submitted a proposed rule that would apply to this to the ARCI. And we're just giving you that report in essence, and that Mr. Medell, we believe, will be involved in developing this kind of rule.
Good.
I don't think it's sensible for New York to develop a rule on its own.
Sure.
If we can do it through the ARCI process. Jeff, am I right in that?
I agree.
That makes sense. Thank you.
Is that everything?
Yes.
Well, thank you very much for coming.
Thank you very much.
Appreciate your
Thanks for having us.
Thank you.